Welcome to the 7 People Podcast, your guide to creating irresistible organizations.
And this week we will dive into how work works, what you can and definitely can't do as an employer. I mean, employment law, we all have to deal with it. Not only HR, but also employees, founders, everyone actually. And what we see in companies is one of the biggest legal blind spots is that founders just fire and do whatever because it's their company. And today we will talk about this topic together with Frank Penders. Welcome, Frank.
Thank you.
And is this something that you recognize? You also work for Startup Scale Up, so
Yeah, absolutely. Yeah.
How?
Well, for instance, when there's the case of underperformance, an employer just sends that message out of the blue. The employee is surprised and is being offered a settlement agreement, but that's not really how it works. So that's actually quite often what I see in the practice. Yeah.
Interesting, because this is literally something that we will dive into later, because we prepared some cases. But maybe first you can start with a brief introduction.
Yeah, sure. Well, first of all, thanks for having me. My name is Frank Penders. I've been a lawyer for about 15 years right now, specialized in employment law. Last few years, I've mainly worked for employers, but I also do some employees as clients. Besides that, I've worked with a great team on a new startup. It's called Settle Sure. It's actually advising on the settlement agreement. It makes cross checks with the employment agreement and the payslip, and then it's an AI-driven tool.
Ooh, cool.
Yeah, so it's like something we're working on right now.
AI to help with settlement agreements?
Yeah. And that helps the lawyers, so they can advise in about 10 seconds what normally takes 3 hours.
Wow.
And we're now building a B2C tool, which helps the employees who've been offered out of the blue the settlement agreement, and they can just check it online by uploading the employment agreement, the payslip and the settlement agreement, and then it generates an advice.
That's so cool.
Yeah, that's what makes my work dynamic. Just not only advising employers, but also the other side, employees.
Yeah.
And I actually do believe that you can do your work even better if you advise both sides, actually. Yeah.
Because you understand both sides.
Yeah, exactly. Yeah.
Thank you for the introduction, and thank you for coming today. For today's podcast, we thought it would be interesting to dive into 3 cases that we see quite often at clients. We thought it would be interesting to get your view on it as an employment lawyer, but also your view as a senior HR professional.
Okay.
And the first one is quite a hot topic at the moment. It is about misclassification. So let's say we have a fast-growing startup and it has worked with a freelancer for over a year. He is at the office 3 days a week, uses the laptop of the employer, joins team luncheons, and even leads the project. There's just no contract and only invoices. Now, this freelancer is burned out and is asking for sick pay. I mean, when does a freelancer become an employee? Is this allowed? Do we need to give him the sick pay?
It's actually quite hard to determine whether, in this case, a person is considered as a freelancer or an employee. Mm-hmm. So the Dutch tax administration, the Belastingdienst, has stipulated that it's with this assessment, it looks at the holistic assessment.
Oh.
Meaning that no single fact will be decisive.
That sounds very vague.
That sounds really fake. But in order to help a little bit, the government has given a tool with some questions and a rationale question, a list of questions. Mm-hmm. And parties can just fill it in online. And then you get some guidance in whether it's considered to be a employee or a freelancer.
So, because I think, like in my experience, right, it's quite clear who the employees are because they have an employment contract.
Yeah.
Whereas contractors usually have like a service agreement or some other form of contract, and then the difference really is, for me anyway, let's say the employees are getting paid by payroll every month, and the contractors are sending an invoice. But I guess where the gray area comes in is when we start saying, like basically treating them like employees, right?
Yeah.
Friendployees. Yeah.
Sorry?
Friendployees. Sometimes you hear that phrase. That is freelancer. It's a freelancer, but it is an
Friendployees?
employee. So you call them friendployees.
I'm not. I've not heard that one.
People get creative.
Friendployees. Okay. Yeah. See, that for me is like already a yellow flag, right? If we're saying where we have friendployees.
Yeah.
So yeah, I guess the gray area is like maybe you start off as a contractor, but then you develop a really good relationship. They become like a trusted partner in the business. You work with them for a long time. And then I guess that's where the gray areas start to come in.
Yeah, well, case law has stipulated 9 points which are important to determine whether there's a freelancer or an employee. So maybe we can post it on the newsletter or the show notes, because it's quite boring to sum it up right here, right now. But those, and not one of them is really more important than the other one. But it will help giving you some guidance. But for instance, if you have a freelance contract, which includes quite hard non-compete. So you work at 7 people at the freelancer, but you can't work for other similar companies. Well, that's more going towards an employment relationship, right?
Yeah.
However, if it's just really lean and mean, and you work for 2 days a week for 7 people, and you invoice 7 people, and 7 people can't give a lot of instructions, etc., then it qualifies as a freelance.
So it's kind of like about the controls that are in place, right?
Yeah. That's one of the things that's really important. Yeah, absolutely.
What about then paid time off, let's say? Because for me, like paid time off, if you're an employee, you get paid time off, but then a freelancer, should it be that they just get paid for the hours they work?
Yeah, it's what parties agree upon. But if it's so, you can agree that you can invoice one similar amount every month.
Yep.
Right. Or for working hours. And again, if it's one amount for every month, it's more towards an employment relationship.
Right.
But if you only invoice for the hours you actually work, that's more towards the freelance.
Yeah.
But there's no law or rule which stipulates that you must invoice per hour, or that it's not allowed to invoice for a month. Or for a year, for instance. It's just what parties agree upon.
So just to give you a scenario then. So I could be an employee. Sorry, I could be a freelancer. My agreement could be, okay, I'm going to invoice the same amount every month, regardless of the hours I work. And we could agree that.
Yeah.
And maybe it's 10 hours, maybe it's in a week, let's say, or 40 hours. And that could still be classified as a freelancer relationship.
Yeah, absolutely. Because if you, and that's why you have to look at every case particularly. And for instance, if you invoice per month, and the tax administration asks, why have you chosen that? And you say, well, because of there are 300 hours I need to work on this project. And in January, February, I'm working 10 hours. And March, April, May, I'm absolutely packed with this particular assignment. Then the rationale behind the invoicing, not quite. If it's that logic, but there's a rationale, right?
Yeah, it could be like, it's an average.
Yeah,
6
sure.
months.
Yeah.
But is it then...
and less administration hassle, etc.
But it is then not allowed to, for example, say I work 40 hours a week every day from 9 to 5:30. Or is that allowed? Because that's...
It is allowed, but again, if you have the 9 to 5 job, it's more towards employment.
Yeah.
But if you can argue and state that because only for that period of time, it's really necessary for that project to work full time on it. And after that job is done, you can work for other projects, other companies. Then I don't see any problems with that.
Okay.
It's all about your explanation behind the rules and behind the contract, and that there's no one circumstances is being really decisive on the whole assessment. Yeah.
Okay.
Yeah. So like 40 hours a week for 6 months with just one company would be okay. But if it's for like 3 years and you didn't work on any other companies, then maybe that would be
full time for 6 months. It's a gray area,
really?
I guess.
Wow.
Yeah.
Oh. We do see that quite often, to be honest.
And it's if you ask me personally, I think it's quite weird that the government now is being so harsh towards the freelancers and the companies. Then if you look at the government, there are working so many freelancers nonstop for the government.
Yeah.
And there are no employees. So that's not that.
Yeah.
And what is the risk exactly?
Well, if you're having an employee, you have to pay premiums, etc. Right?
The social tax or whatever it's called.
Yeah, exactly.
Social payments. Yeah.
And the key issue if you can just terminate in collaboration, because when you're an employee, you have you have to have a formal dismissal ground.
Yeah.
Or you have to go to the court, or you have to go to the UFA to fire someone, or by means of a settlement agreement. But if someone is a freelancer, you can have a look at the contract and see what the notice period is. You give notice, and then the contract ends. But if it qualifies as an employment agreement, that's absolutely not possible. That's really important. And besides that, for a freelancer, it's good to know that you cannot have any unemployment benefits, and after the contract, and as an employee you can.
Okay.
So it sounds like the main risk is like, number one, it could be seen as tax evasion, right? Because contractors are cheaper. And the second one could be an abuse of labor law, because it's more in favor of the company because they could just let go of you easier.
Absolutely right. Yeah.
Cool. And then it's also the tax risk. You have to pay it back, right? Retroactively.
Yeah.
In most cases. And in the Netherlands, it's quite risky, and in France as well. But there are also some countries that are a bit more of a low risk area. And how does that exactly work? Because, for example, if you have a lot of freelancers working in, name a country, I don't know, South Africa or Suriname or you name it, do we then have to follow the same rules, or do we have to follow the rules of that country?
But I think your question, Flo, is because what we see a lot is, let's say a Dutch company will have its headquarters in the Netherlands, and then most people in the Netherlands will be employees.
Yeah.
But then we will use we'll offshore certain teams because the labor might be cheaper in another market.
Tech teams, for example.
All right.
Yeah, for example. Yeah. And then obviously you have to follow the labor law of that country, but I think in some countries the risk of classification is higher. Like in some countries they're looking into it more than others.
So here in the Netherlands, because now we're quite on top of it, it's maybe a higher risk than, for example, in, I don't know, another third world country where they not really care.
Yeah, but do the people then also live there, or? Yeah.
So they work remote. They have a freelance contract. They have a company there. But we are a Dutch company with an HQ in the Netherlands.
All right. Yeah.
Yeah. My question is, is it then okay to follow the labor law in their country, or?
Yeah. Two important things to look at is, where does the employee live?
Yeah.
And where is the work being done?
Okay.
So if those two points are abroad, then I believe that the law of that country is applicable.
Yeah. Okay.
Yeah. So I guess the point is that, let's say the Belastingdienst or the Dutch government are not going to be too much worried about my freelancers in other countries, but I'd have to be thinking, okay, am I complying with the laws in that in that region?
Yeah, true.
Yeah. Okay.
Cool. That's clear. Because and let's say now I work for a company and I figure out, oh God, we have like hundreds Friendployees or freelancers that are actually employees. The government or the tax authorities are really on top of it. I want to fix this. Can you retroactively fix this problem, or say, okay, from now on you're an employer or employee, from now on we stop your contract, or how do you do that?
Well, sometimes what I see in contracts is that there's this clawback clause. Yeah. So when the tax administration makes an assessment and says, okay, it's not a freelance contract, but it's an employee contract, then the company can shift the economic risks towards the freelancer.
Okay.
That's not for the whole amount legit, but for some parts of it is. But if you, so that's the first tip. Look at your contract and then just adjust it. Yeah, why not?
Okay.
If both parties want to continue working together, then you can just end the freelance contract and start an employment agreement, and then that should be okay. Yeah.
Okay.
So you can adjust it from like tomorrow or today onwards, but we couldn't like retroactively change.
No, that's not really possible, I guess.
Yeah.
But it is a good tip to be aware of people who are working in your organization, obviously. And if a freelancer is doing such good work, and you really want to keep him in the company for more hours, for a longer period, then actually my advice is to just conclude a employment agreement. Yeah.
Yeah. A lot of freelancers don't want to because of money.
Yeah.
That's what I, for example, see quite often, that you start a conversation like, hey, maybe.
Yeah, but they quite often want best of both worlds.
Yeah.
So when they don't want to pay taxes, they want to earn more money.
Mm-hmm.
But when the shit hits the fan and they're being laid off, they claim, well, I'm actually an employee.
Yeah.
And that's not that fair, in my opinion.
No, but it is a risk for the employer, right?
Yeah, absolutely.
This can happen.
Yeah.
Okay. Risky business.
Yeah, it's a risky business. Absolutely. And besides the tax and the financial upside for parties, it isn't that bad just to conclude an employment agreement. Why not?
Yeah.
And you can start with a fixed term contract, and then you can just maybe renew it. But yeah,
like start with 7 months, 12 months.
Yeah, but still, I think a lot of freelancers really don't want to, because they can get a lot of more money at the end of the day, working as a freelancer and not as an employee.
Yeah, it actually has shifted during the last years. So there's a big wish from people that they want to be more flexible, want to have more companies that they work for. And then for those cases, for those situations, it's absolutely perfectly fine to be a freelancer. However, if you have those free assignments and one is really paying well, and you start working more and more for that company, then at one time it will qualify as an employment agreement. So then, that's the downside of it. Yeah.
So to mitigate the risk, maybe one tip is to put in the clawback clause, or how did you call it again?
Yeah, absolutely.
So you not as an employer only carry the risk, but it is the risk of the employee and the employer together.
Yeah.
Nice.
Thank you.
Okay, so that's misclassification, and we just started talking about contracts.
Yeah.
So I think that's a good segue into the next case. You had a case on contracts, Claire?
Case 2 is indeed about contracts. So a third fixed term contract is about to expire. And you were not really sure about performance. So do you go permanent? What if you're unsure? Maybe it's a question for the both of you, because what are the rules in the Netherlands around contracts, and what should you do in a case, this person is nice, doing a fine job, but permanent, I don't know.
So you're asking me?
Maybe first ask you, what would you do in a situation like this?
So my opinion here, just, and like obviously when we work in HR, it's kind of, we're not lawyers, right?
No.
So we're more like business advisors who have knowledge of HR topics. But my opinion is, if you're not sure, don't extend. For me, I particularly when it comes to permanent, because there's a lot of protections for employees when they're permanent. But I always advise companies when it comes to contract extensions, I'm quite binary with it. I'm like, you either back this person, you either believe in them, or you don't. And like, it's quite that simple. And if you believe in them, let's go, let's extend. And even for a second 12-month contract, for example. But if you don't believe in them, then don't extend. For me, I'm quite binary about it like that. There are some exceptions, maybe something happened in their life and, they had burnout and they're recovering, and then you want to give them a chance.
Yeah.
So there are exceptions, but for the most part, I'm like, you either back them or you don't.
And if somebody got a burnout and they're recovering, for example, would you extend with an indef?
It really, really depends on the specifics of the case. There can be scenarios when you do, it might be that, they're in a specialist role, like, for example, with AI, right? Like AI engineers and machine learning engineers are very, very valuable, and they might be the only person that knows something.
Yeah.
Or it might be that because of the specific of their case, you want to support them. So it depends on the company culture as well.
Yeah.
So it depends on some different factors.
Okay, clear. But third fixed term contract, unsure, don't extend.
That's what I would
what
advise.
Paul thinks. And how does it then work with the rules in the Netherlands? For example, it's a third fixed term contract. You have something.
I actually agree with Paul because, in my opinion, it's already quite flexible. So in the period of 36 months, you can conclude 3 fixed term contracts.
Yeah.
And we're talking about 3 years.
Yeah.
And if you're not aware of if you want to continue with each other, then I guess the answer is no.
Yeah.
Yeah, and also I would give similar advice even after the 12-month contract. So I guess we can.
It's a long period of time, right?
Yeah, exactly.
Yeah.
So
I actually advise to start with 7 months, something like that. Yeah, but yeah.
Yeah, but let's say we extended the contract and we gave them an indefinite, and we're like, oh no, this is not working out. The person is not performing, or I don't know, something happened. Can be anything. Can you then still offer a settlement after the contract renewal? How does that work?
Yeah, actually you can offer a settlement agreement at any time you want.
And for example, do you need a PIP for it or anything, or can you just offer it always?
Well, actually, that's one of those blind spots we've talked earlier about. It's if it comes to a surprise to an employee by offering a settlement agreement, I guess it will backfire because they will be quite overwhelmed and they will not understand the situation. And that's where the argument starts, actually.
Exactly, where you smack it on the table in the middle.
Yeah, exactly. Yeah, so it's all about documentation and really trying to improve if someone is underperforming, and not just building up a case, but really give it a chance. And then I do believe that an employee will think, okay, this is not the marriage we've wanted, so agree to disagree, and let's split ways.
Yeah, because what I see quite often in start scale up world is that a lot of stuff around performance and stuff is not in place yet. So the decisions that are made around contract extensions are still quite subjective.
Yeah.
And it happens quite often that they then say, oh, we don't pay a lot of money. So we're going to give you the trust and give you already an indefinite, because they think, if we don't like it, we can get rid of them with a settlement anyway. But I'm like, is that the right approach? Because we just talked about that is quite the risk, right?
Yeah.
So that was my question, like, is that a right approach and thought process, and what are the risks around this?
Yeah. What do you think, Frank?
Well, again, the period where parties have some flexibility is 36 months, and I guess that's quite already a long period. So why choose the tool for an in-depth that fast, actually?
Yeah.
Because let's say what we advise companies is after we start off with a 12-month contract.
Yeah.
Depends on the role. Maybe if it's for like a customer support role or a more operational role for a different profile of person, we would start with 7 months.
And give some trust, not to go with 7 months, but for a year.
Yeah, it's like if it's for like maybe a software engineer or mid-level senior professional. But then we usually advise, okay, for the second contract, for the reason I mentioned before, if you're not sure, then it's just part ways. But if we're sure, let's go for the indefinite.
Yeah.
So that's what we usually advise. Would you advise that as well?
Yeah, because if you enter into an agreement more than 6 months, you have the possibility to conclude a probation period.
Yeah.
That's always useful. I understand that advisement. Yeah.
And also because from the employee perspective, then they feel like they get more job security, right?
Yeah.
So that's fine. But I think this is what your question is, Flo. Is like, well, why bother with the 3 back-to-back contracts?
Yeah.
If we can
offer a settlement. At any time.
Yeah.
Like that is a bit like, why wouldn't we do straight away an indefinite if you want to trust your employee, and if you can offer a settlement at any time when building up a case with good reasoning, why wouldn't you go for an in-depth straight away?
Yeah, because it will take time and negative energy, and you have to pay legal costs. And if you have this fixed term contract, obviously it will end by operations of law, and then you can split ways on that. Yeah. So the advice is just to start absolutely with the fixed term contract. And of Toba, I actually agree. And from that, just look at where's the company standing actually. Yeah. And besides that, if you enter into an indefinite contract, then and you want you've made a horrible choice. What you said, there's always a reason laying underground. So why is it a horrible decision?
Choice.
Is he not performing well? And then are there economic reasons? And then you just look at those real reasons why you want to lay off. And explain that to the employee, and then you can start on a PIP process. Or you go through the UWV because of those business reasons why you have to lay off him.
And how do you build up a case? Like, how do you do that right?
And you're still talking about VSO, right? You're not talking about like a contract termination
exactly.
where you're talking about VSO. So a settlement agreement, okay.
Well, I guess not just for the sake of paying less when it comes to a settlement agreement. But really trying to improve and see what you can do as an employer to help the employee. I'm aware that this is not always going down like that in practice, but that it is the genuine advice I can give. And besides that, make sure that you document everything. So if you are improving and you have meetings, make sure that you just confirm it by email on a positive way, saying this went better, this is not going that well. And if you keep that up for 3, 4, or 5 months, I do believe that also an employee will think, okay, is it going to fly or not?
And at some point, if it's not flying, also maybe for you as an employee, it's time to think maybe it's not the right match. And I was just wondering, like, can't you just hand it to them now? Frank said maybe not so smart, because probably then there will be a conflict or something will explode. So you need to build up a case and like massage it in a bit.
So personally, I wouldn't use the word necessarily case, but it's like you escalate. You start to escalate. So
how would you do it?
Slowly the language starts to escalate.
Okay.
So because as Frank said, you don't want to just turn up one day with a settlement agreement and say, hey, I want to break up with you. Because it is like you used the word marriage before, right? And it is a breakup. It's basically we're having a breakup, right? So
and it's personal.
Yeah, exactly. And so you want to start using language like, like I'm not sure this is going that well, but then also get their perspective, right? Because a lot of the time when you ask them like, oh, how do you think it's going here? And then they'll start to tell you, actually, I'm not too happy, because when you're not performing that well, you're not that happy either. So then you can say, well, okay, well, there are like alternatives we can consider. You see what I mean? So it's not just like all of a sudden out of the blue, the settlement agreement. It's having like the open conversation, like how do you think it's going? Are you happy here? What are your long-term goals?
And
making sure, because sometimes people are not aware there's an alternative. Because there's staying together, there's like me breaking up with you, which would be a termination, and then there's like the VSO, which is a mutual agreement. So that's the third.
The nice route. And do
Yeah.
you always have to offer money in a VSO? Like what do you normally offer when the VSO is on the table? What is like stuff you need to put in there?
Wait, hold on a second. For the English speakers.
Vaststellingsovereenkomst.
There we go.
VSO, settlement agreement.
Well, curious, what do you advise?
Well, like I think the thing is with a settlement agreement, I always find them quite flexible actually, because it's me and you agreeing something. So we can pretty much agree whatever we want. We can obviously I have to pay you your salary up until the termination date. But we could just agree that. So it depends on the circumstance.
Whatever. Okay. So but
the way I see it is that, let's say maybe a better example is when we're doing a restructure, right? So when we're doing a restructure and then we decide, okay, because of economic reasons, we need to let go of 20% of the headcount. Then that's the scenario where we will start to say, we would advise the CEO of the company to say, the performance is not going that well. We're trying everything we can. We've got a hiring freeze. We've got a travel freeze. We're trying to save money. So we start to, again, build up the language, escalate the language.
The case.
And people are like, oh, okay, something's going wrong here. It's not like everything's great out of the blue layoffs. So again, it's an escalation.
And that's good advice, actually. Yeah, absolutely.
And the CEOs are usually trying to protect the people as much as possible for as long as possible, but they also have to think about the runway of the company. But in these scenarios, then we would want to offer some money, like settlement amount, because we want them to sign the agreement.
Yeah.
Right. And so we're financially incentivizing them to sign the agreement, because if they don't sign, then the other option is we'd have to go to the canton rector to get a termination. And that takes time and costs money.
Yeah.
So therefore, that's why you offer something.
And how do you then know how much to offer?
You can look at the formal dismissal route through the UWV. And then you'll think, okay, if I ask for the dismissal permit right now, when will the UWV most likely will grant it? So it takes about 6 or 8 weeks to go through that process.
Yeah.
After you get the dismissal permit from the UWV, you have to bear in mind, you have to give notice. There's the notice period. So then you're already quite a few months in time. And that's the minimum. And besides that, there's no legal obligation to, when you enter into a settlement agreement, there's no legal obligation to offer a severance payment. However, an employee will think, what are my chances and what will I get if I just go through the UWV process? And after I'm being laid off with the permit, the employer will have to pay in Dutch it's called transitievergoeding. So that's also something that I should definitely want to offer in a settlement agreement. So look at the timeline, look at the transitievergoeding, and maybe something a little bit more. Or there must be an incentive for an employee to agree upon a settlement agreement, and it will give parties less negative energy. Maybe when he signed or she signed the settlement agreement, you're released from your duties, so you can look elsewhere, etc. Yeah.
Okay. And sometimes you also hear a signing bonus. So if you sign,
the signing bonus is just another word for the settlement amount.
Okay.
Yeah. So that's what we mean by that. So what I'd usually say is, okay, well, look, I'm giving you notice today. That means we pay you up until the end of next month. We're going to give you the transitievergoeding, and if you sign this within a week, obviously getting legal advice, here's €1,000 to go speak to Frank to get legal advice. If you sign this week, then we'll give you the signing bonus, let's say usually around 3 months, because that's how much I'd have to pay you anyway to go through the process of the UWV. That's why we call it a sign bonus, but sometimes you can refer to it as the settlement amount.
Okay, that's clear.
But this is, let's say, a more standard case, but it can also be maybe I'm a CEO or C-level person, and I've just hired a director or VP or another C-level person, and I say, you know what, I made a huge mistake hiring you. We need to part ways. Then it might be a bit different, right? Because they maybe have left a super senior role at another company and changed their life because they believed in your company. And then that's when you start to see the numbers go up. But the reason they get a bit higher is because we want to end the agreement we want to agree in an amicable way.
Okay.
Then, another example is maybe you relocated to the Netherlands, brought your family here, moved your life, your kid is in school, you have to pay for that school.
Yeah.
So then it's like...
If you look at the numbers, the employer and employee are not going that much to the UWV or to court. So the settlement agreement, I guess it's not quite sure. It's about 80-90% of the layoffs by means of a settlement agreement. Yeah.
Because you want to avoid going to the UWV or court, of course, because it's
there
lengthy...
are risks involved for both parties. You have to pay your lawyer.
And you're not in control of the process.
Exactly. Yeah.
That's a risk.
It's always a risk what the UWV will say or what the judge will say. Absolutely.
We're moving on because let's say it does escalate and you need to go to the kantonrechter. Kijk, what do you need to do? Like, how can you prepare for that?
Because of underperformance?
For example, yeah.
So if I look at case law, I see that the court rules a lot in favor of the employee.
Okay.
Because there isn't a well-documented file there. And the employer hasn't done enough to actually improve the employee. So my advice is to really document everything really good.
Yeah. Not
just for the sake of going to court, but actually really want to improve on an employee.
Yeah.
And if it's not going to happen, then look at other possibilities, maybe for another role within the company, and have those conversations going. If it's because of an argument between the employer and employee, maybe suggest mediation. And if you have followed all those steps, case law says about 3 to 6 months, which is a long period of time because it's if you have to go to work every day not feeling happy because the employer thinks you're doing a shitty job,
that's awkward.
Because of that, you see that during that process, settlement agreements are being concluded. Because you just don't want to go to court, but you don't want to go to your job when the other party is not being happy.
Oh,
and that's the marriage thing again.
And so, what does the indeed, you don't want to live in a
in a house
marriage, right?
with somebody that you kind of broke up with.
If you're communicating in an open way, then it will not come as a surprise, and then it will not be a court case.
Oh,
yeah.
I think we need to move on to the intermezzo, because I prepared a few statements.
Ooh.
And you have to say if it's right or wrong, and maybe also give a bit of context why. So, statement number 1: you can dismiss someone during a probation period without any documentation. Just
False.
say, okay, why?
It needs to be concluded in the agreement. Actually,
Okay.
yeah. So if an employee asks for a reason, you have to give it. As an employer, but there has to be documentation. Actually, the probation period has to be concluded in the employment contract.
Okay, and also, of course, confirm by email that you're not extending somebody.
It helps.
Yeah, it helps.
Yeah.
Okay.
So just to check that, so obviously there needs to be something mentioned in the contract about probation. So you have a probation period of 1 month, but then you're also saying there needs to be a reason as well. I can't just say, I'm not going to tell you. I have to say performance or culture fit or whatever.
Maybe not the best chic tip, but keep it bit fake, right?
Yeah. Okay, cool.
And then follow up with email.
Yeah.
You didn't pass probation for these reasons.
Statement number 2: it's allowed to sign a settlement without giving the employee legal review.
True.
Okay.
There's no rule, law, or whatever which states that the employee has to be given the opportunity to seek legal advice.
That is something that happens quite often, though.
I think it's like best practice.
Best practice.
Yeah.
Okay, interesting.
True.
I didn't know that. I thought you had to, but
But I think it's just a nice thing to do.
Yeah. Softens the blow.
Before there was this the thing you could dissolve the agreement when you could actually state that you've signed it without being really aware of all the consequences. However, since a few years, there's this new law which states that an employee has the right to dissolve the settlement agreement within 14 days after signing it, if it's being mentioned in the settlement agreement. And if you keep it out, then it's 3 weeks. So that also already gives the employee some clawback tools.
Okay, time to think.
Yeah, time to think, yeah.
Okay.
What do you call that? Like reflection time?
Exactly, yeah. Reflection period.
Cool off period?
I guess the legal wording is reflection, but it's the same. Yeah.
Okay.
Statement number 3. It's allowed to pull back from an accepted offer. So, for example, in recruitment, I give someone an offer in writing over email. Somebody accepts in writing, and then all of a sudden my number 1 candidate says, oh, sorry, I do want the job. And then you want to pull back from the other candidate that you just handed the offer in. Is that allowed?
I see that you already know the answer.
I don't know.
No?
I'm asking you.
False.
False.
Yeah, if you made an offer and it's been accepted, you have an agreement.
Yeah.
And is that, so let's say I email you the offer document. I say, hey, here's the offer. We're going to offer you this amount of money, 12-month contract, these benefits, blah, blah, blah. And you reply saying, yes, I accept. Then that's legally binding.
Yeah, that's legally binding.
Okay.
So,
But you see, sometimes there's some discussion about a bonus scheme or something like that.
Yeah.
And then you can maybe state that there's no one all-comprehensive agreement being concluded. And then maybe you can try to fix it like that. But if it's just a quite straight offer which being accepted, it's not even necessary to accept or offer by email. Verbal is also
Really?
an
Even
agreement.
on the phone?
Yeah, absolutely. Yeah.
Wow.
Oh.
I mean, obviously you probably want the written to prove it, right?
Yeah,
But,
If we talk about an employment agreement, it has to be written down. Actually, yeah.
Yeah.
and what if, let's say, this situation occurs? How do you then get out of it? Do you then, for example, get like fire somebody in their probation period, or what is the
that's a good suggestion actually.
Painful.
Not that nice for the person.
No.
But,
Savage.
what's the
short marriage?
No, but like, you know what
what's
I've
the
seen,
alternative, right?
What I've seen
Yeah.
work well with this is you're just honest. You just say, hey, because usually something's changed.
Yeah, that should be the noble thing
And
to
it
do.
is
huh?
then
nice
you
to
just-
give someone 1 month's salary, because maybe they also need some time again to
Yeah.
then
Yeah,
look
but if
for
you just
another
call
job.
them and say, hey, look, like we've really, really messed up. This has completely changed. I don't know. We lost a client. We've lost, therefore we have less revenue.
Yeah.
We need to scale back. Like we did really want to hire you, but actually we were unable to anymore.
Yeah, it's a shitty thing to happen because that person already terminated their old contract. You talked about allocation. Yeah, then it's quite harsh to say sorry.
Yeah. And then, so what I would say is like, well, see what they say.
Mhm.
Then you can say, well, you can start if you want, but you know, we don't know how long, even if we're going to be able to extend after your first contract, for example. And then they might say, yeah, you know what? I will look for another job. So.
Yeah. Also, you don't
good to
want to
give
start
people-
there then, I
Yeah,
guess.
exactly.
No,
exactly.
no,
Yeah,
no.
exactly.
Yeah.
It's like good to give
True.
people agency over the
that's
situation.
quite the red flag, I think.
Yeah.
You get a call like that. But okay, that were the statements. Thank you.
Wait, I have a question.
Oh,
that
sorry,
I'm
we
really
do.
curious about, because one thing we talk a lot about at Seven People is when you read like contracts and then you're like, what is this contract actually saying? Right? With all this legal language, maybe not so much employment contracts, but for example, with equity schemes, we're like,
It's
a bit more-
horrible,
Is it, yeah, right? So what I heard is that this legal language you use, people just use it because everyone else uses it. And actually we can just write our contracts in way simpler language. So me and Flo can just make an agreement in very simple language.
Yeah.
So is that something you see or resonates with you?
Yeah, well, yeah, absolutely. Non-compete can be quite of a fuss. However, it's about salary, function, bonus, pension, insurance, travel costs, etc. And if there's something which is fake, just ask, what does this mean? And if you have an explanation by email, then that will help.
So you
But-
try and keep it as simple as possible.
Absolutely,
Yeah.
absolutely. Yeah. If it's transparent and all clear to both parties, then it's less likely to escalate later.
Good one.
Especially with regard to bonuses, etc.
Good one.
Good one. And want to round up with something pragmatic. Let's say, do you have any tips for founders or starting HR people or managers with zero legal background and zero budget? That, for example, hey, if you are in a company, please look out for these things because they can backfire later.
Well, we actually discussed about fixed term contracts for 12 months. That's a good tip, actually.
Yeah.
Use good templates.
Yeah.
And that will help a lot. And be transparent. Yeah.
Because I think at the end of the day, legal advice and transparency really can help your culture. It's not only about avoiding
Exactly,
lawsuits, but it is also giving clarity and transparency. And if, employees, founders, managers, everybody knows the law, then I think a lot of discussions and awkward situations can be avoided, right?
Yeah, and
Absolutely,
it's like
yeah.
it's not like us and them. It's like we're together.
We're together.
Let's make it work, right?
Yeah.
How work works. So I want to round up with that. Thank you so much, Frank, for joining us on this podcast.
Yeah. Cool
And
to be here. Thank you.
Yeah, thanks a lot. I learned a lot.
Yeah, and for the listeners, we will see you next month. And Personio, thank you for sponsoring this one. Bye.